He is not found to be having a knock. He is medically fit for the post of sub inspector. After the passing of medical test, I'm medically fit from the very first beginning.
But that is not settled. No post has been reserved. It is a futile order. It is a meaningless order. It does not give any right to anybody. Don't you think so?
It's only the direction order.
Pardon?
It is only the direction order to
Correct. So
appear.
how that will benefit you, counsel? Ordered for re-examination. That's all. Whether you pass or fail makes no difference.
The present applicant has appeared before the Vyapan examination for the post of sub-inspector. And thereafter, he has successfully completed the medical examination, and in the medical examination, it has been found that the petitioner is knock-knee.
Yes.
After that, my lord, the petitioner has come before this honorable court in the form of writ petition, which is 21718, and it has been directed by this honorable court that if the petitioner is appeared before the chief medical officer Sagar for the conduction of his medical test, then he can apply for the post. Thereafter, he came before the chief medical officer Sagar, and the writ petition's annexure P4 has states that clinically he is not found to be having a knock. He is medically fit for the post of sub inspector.
Who has certified that you are fit for appointment?
Chief medical officer Sagar.
Where is it?
My lord, in the writ petition, page number 14.
Read it.
My lord. While above reference, Mr. Umesh Patkar, so and so, appeared before the Special Medical Board, District Hospital, Sagar. Order dated 9/9/2012. Clinically, he is not found to be having knock knee. For confirmation, he is advised a screenography for both lower limbs from Medical College Jabalpur, Department of Radiology. Thereafter, he has. This is on page number 40 of the petition, on the set of petition. In the second round of litigation, the Honorable Court has found that the advertisement has been closed and nothing can be done after the passing of 11 years. Only this is the basis for the dismissal of my writ petitions.
What is your ground counsel?
My lord, from the first date,
You have applied for the post.
my lord,
It is rejected. Correct?
my lord, it has been rejected in the medical ground. My lord.
It has been rejected. But that rejection is not set aside by the court in the earlier ground. Court only says you go to another examination.
My lord.
That is a futile writ petition, writ order.
After that,
Suppose
we
the
have
selection was set aside or your post was reserved for you,
the
then
post
you
was,
can claim it.
the post was not reserved. My
Then
lord.
what is your case? What ground you are filing?
My lord, but after the passing of medical test, I'm medically fit from the very first beginning.
But that is not settled. No post has been reserved.
It is a grievance that I can.
That cannot be done now. Is anything else?
My lord, only this is the only ground that my
Correct. We may not have any ground to file it at all. Unless there was some order in the earlier petition to save your post.
Two orders has been passed by the
It's only for reconsideration.
is for
That is
reconsideration.
a futile order.
My lord.
It is a meaningless order. It does not give any right to anybody. Don't you think so?
My lord, it's only the direction order.
Pardon?
It is only the direction order to.
Correct. So
appear.
how that will benefit you, counsel? Ordered for re-examination, that's all. Whether you pass or fail makes no difference.
But after the
Suppose the
passing,
order says you re-examine, if he is found fit, you appoint him. That is not the order, isn't it? If that order was there, then it's a different matter. है ना?
the authority has to be
You
responsible
can't
for
raise
this.
any dispute any time like that. No,
My lord, I'm
you are overage now.
on today I am away.
Can we get you a job now?
But the authority, it is the mistake of the authority, man. They have to some.
Agreed by the order passed by the learned senior judge in dismissing the writ petition, the petitioner is an appeal. In case of the petitioner, that the respondent called for applications for the post of sub-inspector in the year 2011.
In the year 2012, 11.
Various persons applied for the said post along with the petitioner, as well as the petitioner. The application of the petitioner was rejected on medical grounds since he was found to be knock-kneed. Thereafter, he filed WP 21718 of 2011, wherein by the order dated 31/2012, petitioner disposed of with the direction that if the petitioner appears before the medical officer Sagar he shall be examined and a report be submitted to the competent authority. When did you appear?
2 times I've appeared before. Two times I've appeared.
The first time, when did you appear?
9th of February 2012.
That also you don't appear on time.
On 9th of February 2012, I have appeared before the chief medical
The
officer.
time granted was 1 week, no? When 1 week expired? The civil surgeon, by his communication dated 19/2/2012, came to the conclusion that he is not found to be having knock-kneed. However, for purposes of confirmation, he was advised renography of both the lower limbs from Medical College, Jabalpur. Where is that certificate? Medical College? Where is that report?
When it is submitted in the petition, it is submitted on the 29th of
Subsequent. Direction expectations from your side.
Okay, go to the bill. Let's go back. Again. Thereafter, it would appear that he approached the medical officer at Sagar and not at Jabalpur. by the order dated 2/3/2020, he sought time to get himself examined at the Medical College, Jabalpur. Thereafter, the report was placed for consideration. Wherein it was held that even though there's a medical error, the same is within normal limits. The same was disputed by the state on the ground that the selection was in the year 2011. And after almost 11 years, no appointment could be granted. Particularly councils, we do not find any merit in this appeal. The single judge having considered the same, what was the review? Firstly, that there is a huge delay in granting any relief to the petition. Hence, the same was denied. On considering the fact it could be seen that there was no judicial order to the extent of reserving any post for it, that the examination of the petitioner that was directed by this court was not a conditional order pertaining to his physical state of affairs. There was no such order to the effect that in case he is found fit, he should be appointed, considered for appointment. The only order was to direct consideration of his medical condition. The same did not lead to any right being conferred on the petitioner to seek appointment. Under these circumstances, we are of the view that after a long lapse of time, it may not be appropriate to grant relief to the petitioner, especially when he has not even asked for the same. In fact, the learned single judge also noted that even the writ petition was not amended, seeking appointment in any particular selection process. Hence, for all these grounds, we find no good ground.